Welcome back. Now, yesterday we discussed the significant backlogs facing the Gauteng High Court, with civil cases facing potential delays until 2031. We heard from the Gauteng Attorneys Association about the court's proposal for mandatory mediation as a way to alleviate this crisis. Let's now talk about the potential impact of this proposal, particularly on one of the major contributors to the court's overcrowded rolls, is the Road Accident Fund. We are now joined by its Chief Executive Officer, Letsoalo. Mr. Letsoalo, very good morning to you. Thank you so much for making time for us this morning.
Good morning, Alden, and good morning to the viewers.
I want to start off here. Yesterday, my colleague, Gauteng Gambi, had an interview with the Judge President of the Gauteng High Court Division, Dustin Mlambo, and I want you to hear what he says about why they're facing this significant backlog and also the contributing factor with the Road Accident Fund. Just take a listen and then we'll get your reaction to it.
It means that there's an avalanche of Road Accident Fund claims, especially those that come to this division. This relates to claims that not only arose in Gauteng but arose in other provinces, simply because the head office of the RAF is here and it's easier for litigants to litigate here. So the first reason is more of that litigation has just kept coming and increased. And the handling thereof, right, from the Road Accident Fund, I think issues reached crisis point when the panel attorney system was disbanded by the RAF. And that led to rising rolls, especially on the default judgment rolls, because a lot of summonses, claims by plaintiffs are totally ignored by the RAF, and they have to be dealt with on the default judgment basis by this court.
Okay, that is the Judge President of the Gauteng High Court Division. Your response to that, Mr. Letsoalo?
Well, as you would know, the RAF has never taken people to court in its outlook. One is that in terms of the law, which is Section 24 of the Road Accident Fund Act, people bring claims. If we don't settle those claims within 120 days, those people are allowed to issue summons. And that's the first part. But when you issue summons, if we defend all those summons, they will result in litigation. So the scheme as it currently works on what is called. When you sue someone, Adrian, that person, the person that you sue, you must sue them in court. You don't sue them anywhere else. And that is what the issue is. And I disagree. The facts of what the Judge President is raising about the panel is not correct, because the numbers, you would see them. And I want to refer you to the Advocate magazine of April 2021 and see what they say there when they say the collapse in RAF litigation has led to difficulties for the legal profession. Simply because we decided that matters must be settled. So it is incorrect to claim that the matters became worse when we did away with the panel. That is totally incorrect, and I disagree with that. Although I agree with the fact that these matters must be for settlement, and we agree with the Judge President on that we must try to mediate these matters because 99% of them end up being settled anyway.
Yeah, on that issue around the panel system and, of course, the legality around that, that's not necessarily what the Judge President is speaking about, but more around how the disbanding of that panel would have led to an increase in the number of cases. And in that interview with Gauteng Gambi, he indicates that RAF was also contacted. There was conversations that took place with RAF with regards to this proposal. Was this issue ever raised during those discussions?
Yes, I mean, we have raised it, and this matter we have discussed it. We have even discussed it at Scopa last week. Our issue is very simple, is that the scapegoating of the RAF about what happens on these claims, it's quite unfortunate, because if you read the Moseneke report, about the Moseneke committee report on issues around the judiciary and the backlogs and all that. You are not going to find the word RAF simply because the issues as it pertains to the clogging of the court roll certainly has more to do with the lack of judges and the establishment that has not grown since 2009 so about. So the reality is that yes, that matter was discussed. And of course, I mean, people will try to scapegoat us, mostly the plaintiff attorneys. Of course, the frustration with the judiciary is that these matters come. For instance, you find that the matter has been put for 2028 in January. We go to 2028 January, and when the matter, and the judiciary does its own plans to have the matter on trial, and it just settled just before, when they have actually put resources to try and look at that matter. So it is correct that the RAF system, and in the way that it sits, creates a situation where we are going to have more of those claims coming to court when they are not supposed to be coming to court. Because remember, lawyers make money from correspondence, from all those things in litigation. If you settle a matter, the lawyer does not make such much money as it would be if the matter was not taken to court.
Okay. What's your response then to this proposal for mandatory mediation before the matter is put on the civil court roll?
200% support. We support that fully because that's what we've been saying. Let's settle matters. There's no need for matters to go to court unnecessarily, especially where these matters are simple merits, right? These matters are simple merits. A person is a passenger, a person is a pedestrian. The merits are all there. We can settle these matters. But the plaintiff attorneys are more interested in taking the matter to court, and that's where they make their money. Because legal costs don't come as a consequence of settling matters. They come as a consequence of exchanging legal documentation and all those things that come with that. Especially, you can see it, I'm saying 99% of all RAF matters that come in front of any court end up in settlement. And therefore, there is no need for the judicial involvement. And we agree with that. We are saying there is no need to waste state resources. We should be using judges for other things rather than RAF matters. We agree fully with the judiciary on this one, and we'll support them.
Yeah, and with the aspect that you just highlighted now, with attorneys and lawyers wanting to make money because essentially they're also running a business, the judge president mentions that there's Rule 41A of the Uniform Rules of a Court in South Africa, which of course promotes mediation, and he says that the lawyers haven't been taking up that mediation. How sure are we now that once it goes through this mandatory mediation, that there won't be an issue that is raised that will actually force the matter to again appear before a judge?
Well, there must be efforts. What we have seen now has not been efforts. And we are saying that at least at that point, there must be something coming from the mediator to say there has been an attempt, serious attempt, of trying to resolve this matter, and it needs judicial intervention for it to be resolved because it can't be resolved. We are quite comfortable that once this happens, there is no way in which we are going to find ourselves in this space because there will be someone who says, indeed, the parties have actually tried their level best. We are not saying that the mediation will resolve all the matters, but we are saying most of the matters that are settled, in any event, will end up being settled before they clog the court.
All right. Thank you so much for that. Just quickly before I let you go, Mr. Letsoalo, one of the issues you just spoke now about your appearance before SCOPA. I saw a statement that you issued on the 24th, and this is in relation to the apology letter that you had sent to the SCOPA chairperson, Songezo Zibi. Just bring us to light around what happened there, because in the committee you were quite clear that the interpretation that the chairperson had was actually incorrect, but then later on in the letter that was sent to him, you said that indeed you had said affirmative that there is a treasurer, but which wasn't the case.
Well, there was a difference between a word treasurer and treasury. And I mean, as you discuss all these matters, I have said I don't want to get involved in this matter. Simply put, I was mistaken by saying treasury instead of the treasurer, because we have a treasury, we don't have a treasurer at the RAF. And that's the difference. And that's why I consider So what is the issue there? What turns on it really, Adrian? Because nothing turns on it. Whether what I said, I mean, what is the biggest issue? I'm saying I have considered there is no need to go into all those other matters. And I'm disinterested in a public spend, as it were. I mean, I don't even understand the point at which someone takes this thing to his own personal Twitter accounts. Those are issues that we'll deal with Parliament on. I don't want to get involved on those matters. I've got a way in which we must deal with these matters. There is no, the matter is settled. He was right. I was mistaken. I have raised that issue and I have clarified it. So I don't understand what the issue is about.
Yeah. Will you be engaging with him around how this matter was handled, as you say that you don't understand why this apology was then shared on a public space?
No. There's nothing wrong with an apology said on a public space. All I'm saying is that on your personal Twitter account, he is a chairperson of SCOPA. We respect that, and he is also an individual. I'm a CEO. I'm also an individual. I can't be taking matters that are dealing with RAF and taking them at a personal level. I think that is wrong, and it's something that I'm going to take it up with him. All I'm saying is that I'm not interested in a public spend about this matter because it's quite clear, and I think it's settled.